Hi everyone, thanks for joining us this afternoon on our final part of this three-part webinar series organized by SFA and Personal Data Protection Commission. So today's session will be on how you can enhance your business competitiveness and strengthen trust with your stakeholders by building strong data practices in your organization. This also means that from today's session, you'll be able to, one, effectively manage GI risk while safeguarding your interests as a data owner, and also learn about the best practices when negotiating contracts with the ICE. So if you have any questions along the way, please feel free to leave them in the Q&A section below, and we'll address it at the end of the session. So without further ado, I'll hand it over to Justin.
Great, thanks, Glenn. All right, so good afternoon, everyone, and welcome to today's webinar. For those of you who are at either the second session, the first session, or both, welcome back. Good to see you again, and thank you for your diligent attendance at this webinar series. As mentioned, I am Justin. I am the PDPC appointed speaker, assisting or working with SFA to deliver this three-part lecture series on data protection to SFA members. And today's topic is about knowing your data intermediaries and mitigating data protection risks. As mentioned, this is the third and final part of this three-part series. In the first one in April, what we went through very briefly was an overview of the PDPA and its obligations, as well as the different tools and resources you can use to comply with the PDPA. In the second session, we focused specifically on the idea of a data protection management plan and how that can be used to create an effective framework for an organization, especially at the management or board level, to develop a proper and comprehensive data protection management framework within the organization. And finally, today we're going to focus on a very important and somewhat narrow but not quite topic of data intermediaries and how we can mitigate that key risk area when it comes to data protection. So as mentioned, just a very brief recap of what we went through. We started this series by understanding or going through the overarching framework of the PDPA, how it came about, and the fact that it's kind of split and strikes a balance between the rights of individuals to protect their personal data, as well as organizations to use that data for reasonable purposes. We then went through the various data protection obligations that we talked about, and how the obligations are kind of divided into the life cycle of data within an organization, starting from collection. After you've collected, how do you take care of it when it's within your possession and control? Finally, the last bucket would have been how do individuals exercise their rights and autonomy over their personal data, and how all of these obligations are kind of underpinned by the overall umbrella obligation of accountability, how that can be put into practice. So today, I think the topic of data intermediaries is a key one. And I think in this sort of part setting out the different data protection obligations under the PDPA, this concept of data intermediaries and the risks arising from that really comes into play when it comes to obligation number 6, the protection obligation. Because I think when it comes to personal data, this is probably the most important obligation, perhaps, and also the one that's most easily tripped up. And the big risk when it comes to data intermediaries is when you engage them to handle or process personal data on your behalf, you're effectively taking your personal data out of your own hands and putting it in the hands of another third party, right? And as you can imagine, the risk on that could potentially be significant if this third party is negligent or doesn't manage the data properly. And what we're going to talk about today is how do we mitigate that risk? How do we manage it? How do we manage your data intermediaries or third-party data processors in such a way that sufficiently protects your organization, not just in terms of complying with the PDPA, but just generally in terms of managing them and the relationship and overall both the legal as well as the reputational risk when it comes to taking your valuable personal data of your customers, your employees, or whoever, and handing them over to someone else to help you to process it. Right. So as I just alluded to, managing data intermediaries is a very important thing to consider nowadays, for a number of reasons. But in particular, given that today's economy is a highly data-driven one, when it comes to leveraging that data that you collect, to processing that data, given the sheer amount of data that each organization has, and really the many different things that can be done to that data in order to benefit your organization, it is quite inevitable or quite likely that your organization uh, would turn to engage the services of a third party data processor to do certain things to the data on your behalf. This could be a very broad range of things, like, a payroll processor to help you help process your employee payroll salary data, to just a cloud storage provider just storing the data, to more sophisticated things like you engage a SaaS vendor to provide you with some kind of data analytics tools. Because it's a SaaS solution, they will need to process their data within their platform, within their environment, in order to deliver those services to you, right? So ultimately, the bottom line here is that even though the PDPC does recognize that it is a reality, is a fact of today's economy, that it is necessary to engage data intermediaries and their services, what is necessary is to make sure that customers have sufficient assurance that these data intermediaries are properly managed, that the safety and security of their personal data is not compromised just because the data leaves the control of the organization which they have consented to give their data to, and is now in the hands of their third-party vendors. So it's important, I guess it's a very preliminary issue, to understand what is a data intermediary under PDPA and what is the implications of a third party being a data intermediary, right? Under the PDPA, a data intermediary, or DI, is defined as an organization that processes personal data on behalf of a data controller pursuant to a contract. And this can really cover a very broad range of activities. So the key thing is really, are they doing that data processing on behalf of the data controller for the data controller's purposes, or are they doing so independently for their own purposes, separate from whatever the purposes of data controller are? So the kind of things that the data intermediary may do would, like I said, can range very widely, and is not limited to whole number of things like recording the data, holding the data, adapting the data, retrieving the data, whatever. I mean, essentially, it's really any kind of data processing that the data intermediary is doing on behalf of the data controller. Uh, the distinction between a data intermediary and not a data intermediary is quite important, because any third-party vendor or third-party data processor that you pass your personal that your organization passes your personal data to, may or may not be a data intermediary, depending on whether they are processing the data solely for your purposes, or they are taking the data and they are also processing it for their own purposes. And I think in the course of today's presentation, will become clear that it's quite important to crystallize that distinction, so each party's obligations when in compliance with the PDPA are clear, right? And this is important because, as I mentioned, there's a distinction between the two. A data intermediary under the PDPA is only subject to a limited number of obligations under the PDPA. Specifically, they are only required to comply with the protection and retention limitation obligations under the PDPA. And this limited obligation, of course, is only limited to the context or to the situation where they are processing personal data in its capacity as a data intermediary. So in other words, for the purposes of the data controller on behalf of the data controller, right? So because they're only required to comply with two obligations, what that means is that the obligation to comply with the rest of the 11 obligations is still borne by the primary data controller. So even though the data is actually being processed by a third party, not the data controller still retains the obligation to comply with all of the PDPA's obligations. When it comes to the retention and protection obligation, it doesn't mean, again, that just that because the data intermediary is subject to those two obligations, it doesn't mean that the data controller is safe from that, right? Both parties will have to comply with these two obligations. But it's important to note that for the rest of the obligations, the responsibility will solely lie with the data controller. So an example, just to highlight, how this kind of data integrity relationship can arise. A very simple example would be where a business enters into a contract with a printing company to print invitations to an event. The business in order to create those invitations, the business will then give the printing company the names and addresses of its invitees from its contact database, which the printer uses to then print the invitations and print them onto the invitations and envelopes. And as you all can very clearly see, the names and addresses of these people would be their personal data. So in this context, the business, the party engaging the printing company services would be the data controller, right? Because these are the individuals from their own contact database. Because so in other words, they control the personal data that is being processed. The business is deciding the purposes for which the data is being processed, i.e. to create the event invitations and also the means of processing, right? By mail merging the personal data using the addressees, using the invitees' addresses, sorry. The other party, the printing company, is the data intermediary, because in this context, all it is doing is printing the invitations based on the personal data that it is given by the business. Presumably, in this relationship, the printing company is not permitted to sell or use the personal data for any other kind of purpose, like their own marketing or their own promoting their own printing services to the invitees or whatever. So because all they are doing is handling the personal data on behalf of the data controller, they would be the data intermediary in this relationship. Right. So having established, what is the distinction between the data controller and data intermediary in a vendor customer relationship. This case study here is meant to illustrate what I was kind of alluding to earlier, in that when it comes to the obligations of complying with the PDPA, that responsibility cannot be outsourced to the data processor or the data intermediary. The actual data processing work can be outsourced, but the PDPA compliance responsibility cannot be outsourced. Right. So in this case study, from a PDPC decision, what happened was that company ABC, which was a financial service provider, they notified the PDPC of a data breach, right, in accordance with the data breach notification obligation. And what happened was that they notified the PDPC that there was an unauthorized disclosure, of more than 1,000 clients, of the personal data of more than 1,000 of their clients, when their personal data was wrongly included in the notification letters that were sent to other clients, right? This error or issue arose when the company ABC engaged a third party, printer XYZ, to print and dispatch notification letters to their clients. And this printing was done by some kind of specialized software that was provided by the printer XYZ, using the personal data supplied to it by company ABC. When UAT, user acceptance testing, was done prior to the deployment of this customized software, they used standard letter prints, and this was used to generate sample test print results. And based on this UAT that was presented to the company in the course of testing and accepted by the company in the course of testing, actually the testing was not sufficient to indicate or to highlight that there were other kind of letter variations that the software was not configured appropriately to handle. Right. So because they had tested the software using these certain standard letter prints, but not the customized letter prints that they were going to use for these notification letters to be printed, the software ended up messing up, incorrectly including the wrong client's personal data into the notification letters when being printed. And the letters with the incorrect personal data were then sent out by printer XYZ. So in this case, following the PDPC's investigation of the incident, both the company ABC, which was the data controller, and the printer XYZ and the data intermediary were investigated, and the findings are as follows. Right, for company ABC, the data controller, the PDPC found that the company did not provide clear specs to the printer on the letter variations, which led to the incorrect or insufficient testing being done. Secondly, ABC, the company, did not ensure that robust testing was done and did not verify that the software could handle exceptional scenarios, specifically the scenario that they wanted to use the software for, right, to print those notification letters. On the side of the data intermediary printer XYZ, they were also found that by the PDPC that they did not carry out a proper test on the software to handle exceptions and errors. And also they did not have in place checks at suitable stages of the printing process. Because essentially what happened was that they just did the testing before deployment. Once deployed, they just treated it as whatever is printed is correct. They didn't check and they just printed it and sent it out. Right. So they did not have in place checks to make sure that whatever is being printed was actually accurate and did not have the wrong personal data. So as a result of this, the company ABC was fined $24,000 by the PDPC, and the printer XYZ was fined $18,000 by the PDPC. Because I think, okay, I guess this probably not true for in all cases, but in many cases, you will find that the data controller company will receive larger fines compared to its data intermediaries, which is reflective of the overall understanding that I mentioned earlier, that the entity which has the primary responsibility for complying with the PDPA's obligations is in fact the data controller. And that responsibility is not something that can be outsourced to the data intermediary. So with that kind of lessons in mind, what I would hope to convey to all of you during this training session is to help organizations to put in place the frameworks to properly manage its data intermediaries, but also to properly allocate the legal and contractual responsibilities between the data controller and the data intermediary in order to demonstrate to the PDPC that there was in fact sufficient and proper management of the data intermediary by the data controller, thereby allowing the data controller to demonstrate that it has discharged its responsibility and obligation of managing the data intermediary and therefore complying with the PDPA. Right, so in order to understand this sort of management process and the best way to do so, it's important to not just think of it as, okay, I'm going to sign a contract with these people. What do I put into my contract? We would suggest, from the PDC's perspective, that this needs to be attacked or tackled at a much broader macro level across the organization, because it's not just one data intermediary relationship you're going to have, right? It's going to be a whole bunch of vendors who you're going to engage to process your personal data. So it's important to have in place the broad macro level frameworks to enable the organization to effectively manage all of its data intermediaries. And the way that this should be done is through this kind of life cycle that is highlighted on your screens now. And the first step in the process would be at A, governance and risk assessment. To begin with, and I think this kind of mirrors what I was saying in the previous session, in session 2, about the data protection management plan. It always starts with management, right? The senior management of a data controller should understand the risks involved of outsourcing data processing activities and accordingly determine the scope of such activities based on the risks, right? It depending on the nature of your business, it's sometimes or it's always worthwhile to consider it doesn't make sense for me to engage a third party to process this data on my behalf, given the risks involved? Or is it, or given the risks involved, does it actually make more sense for me to not outsource that function and keep it in-house so that I can retain sufficient control and responsibility over that level of data processing and over that kind of personal data, right? Depending on the sensitivity of the personal data involved, the amount of personal data involved, the vendor in question, how reputable are they, how big are they, how solid is their data protection and data security capabilities. Those are all relevant considerations that management should bear in mind. The next part of the life cycle would be the policies and practices, right? So having management having set out or identified those risks and having decided that, okay, I want to move ahead with outsourcing this particular function, then there's a need to develop the relevant policies and practices when it comes to the actual management of data intermediary, right? And this again will need to be done with sort of the input and buy-in of management, but it would be probably developed at more of operational level, right? Because this comes down to the day-to-day and specific business unit requirements of that particular data processing in question. Next, the next part of the life cycle will be C, so service management. So having established your governance and risk assessment framework, having established the internal policies and practices, now it comes to implementing those policies and practices into your relationship and into your management of the data intermediary, right? And in this case, an accountable DC not only develops and communicates its policies to the vendor, but it also will have to put in place monitoring and reporting structures to make sure that the DI is aware of those policies and continues to be in compliance with them throughout the vendor engagement time period. And finally, after the services have ended, you're going to exit the relationship with this vendor. It's important to have exit management plans to ensure both business continuity in terms of no disruption to the personal data handling, but also that the whatever data you have handed over to this vendor is managed properly in the sense of they're either deleted, destroyed, or returned to you once they are no longer required by the vendor in this relationship. Right, so going to each of these areas of the life cycle in a bit more detail. Again, starting with governance and risk assessment, as I mentioned. And the message here is that good accountability practices, as with all aspects of accountability with the PDPA, always begin with the organization's leadership and governance structure. I think I can't emphasize this enough because I think having spoken to a fair number of DPOs, how difficult or easy their lives are always depends on how much buy-in and support they have from their management team. If the management is not interested in data protection seriously and it just throws everything to the DPO to do, obviously the DPO is going to have a very challenging job, right? Because they're just trying to swim upstream against the overall direction of the business that is set by management. But if management kind of sets the right tone when it comes to governance and risk assessment, and this is not limited to data intermediary management. It cuts across to all aspects of data processing and data protection compliance. If the management sets the right tone, the DPO's job, the business's job is much easier when it comes to actually developing processes for data protection compliance, but also operationalizing them. Right. So as I mentioned, when it comes to this kind of management, governance, risk and risk assessment, the key things that they need to assess and determine for each instance of data processing outsourcing would be to first establish the business objectives and requirements for the outsourcing. Next, determine the scale and the sensitivity of the personal data that will be being processed. Next, identify what are the high-level risks that may arise when it comes to this kind of processing, and when it comes to selecting and evaluating which vendor you're going to go with for this particular outsourcing. And finally, identify what are the requirements that you want to set out in the contract with the data intermediary. So having identified all these things, it's then incumbent on the management working with the guys on the ground, of course, to first scope the data processing requirements, accordingly based on the level of comfort of outsourcing that they've determined on. And next, select and identify which DI that they feel is able to meet that scope, meet those requirements of data processing. And the things that they will look at really will be what is the organization's track record in data handling, what kind of security commitments do they have, what can they commit to you in terms of data security and data processing. Do they have policies and practices and training for their staff that convey a seriousness and a level of capability when it comes to data protection and data handling, things like that. Right. So then the next phase would then be developing the policies and practices for data intermediary management. So I guess at a management level, that's kind of more broad-based, more high-level risk factors and risk analysis being done. And at this stage, what's being done is more in terms of, okay, at a day-to-day level, at a very operational process by process level, what are the specific policies and practices of the organization when it comes to data handling that you want your data intermediary to comply with, right? And having set these policies and processes, how are you going to communicate those clearly on your data to your data intermediary? And how are you going to bind your data intermediary to them? This is where the contract for the data processing agreement or whatever service agreement comes in. Because I guess when it comes to vendor management, there's always two levels, right? And coming from a lawyer, I think this is quite reflective of how things are done. In a sense of the first level is always the contract, right? What does it say on paper? And the contract is always the ultimate fallback or governing tool that the parties will look to when determining what is the exact responsibility or commitment or obligation of the data intermediary when it comes to handling the personal data of the data controller. But beyond that, it's important to think at a more sort of real world day-to-day level, right? Because what's on the contract is what's on paper, right? The paper will definitely say, the paper is definitely important and definitely says important things, but it doesn't really mean much unless it is translated directly into the actual day-to-day operational relationship between the customer and the vendor, right? And this is where having good communication structures comes into play, having good monitoring processes comes into play. And I think that will be dealt with in the next slide when we talk about service management. But I guess it's important to bear in mind that the contract is one thing, but when it comes to the operational management, that's another key thing as well. Right. So as I was saying, having developed those policies and processes and having set them out in your contract, having imposed them on your vendor in a very detailed and robust way, this is the next critical area that you need to think about or you need to look at when it comes to managing your vendor, right? And ultimately, what we're concerned with here is to make sure that you as an organization, you have developed and communicated your data protection policies to your data intermediary, together with, importantly, having in place the appropriate monitoring and reporting structures to make sure that whatever policies you've communicated to them, whatever contractual obligations you put in your contract are in fact being complied with by the vendor on a day-to-day basis. This can take various forms, but different things to take note of would include onboarding and training. So when the vendor first comes aboard, you communicate clearly to them what you expect when it comes to the vendor relationship, when it comes to data processing, when it comes to data handling, management meeting with the DIs by having regular meetings with them to ensure that they are appropriately supervised, that you are aware of at all times what is going on. They report to you, they tell you what's going on, so that you can assess through those meetings whether in fact they are complying with what you've told them or they're not, right? In addition to that, in addition to those meetings, there can be other forms of more proactive monitoring that you can put in place. I guess this depends on a case-by-case basis depending on the nature of the services involved. But this, if possible, would be a good way to make sure that you have in place that kind of monitoring structure to make sure that they in fact are playing by the rules that you set. So what this could involve would be things like database access monitoring that provides real-time or close to real-time dynamic review of access activity to identify possible unauthorized access or disclosure. So in other words, if let's say you have a database that you are giving them access to perform certain data processing activities, you have in place the technical monitoring tools to make sure that the vendor only accesses that database and is not accessing any other database. That, and also, if the vendor has been given the rights to access the database, it's also important to make sure that the vendor's access activity, you monitor it to make sure that it is not out of the ordinary. So like, for example, the vendor suddenly is accessing the database on a weekend, for example, but you didn't give any instructions to them to do any kind of urgent remediation or urgent troubleshooting to that database. But for some reason they're accessing on a weekend. If you have in place the tools to flag that out, it could potentially highlight and alert you to the fact that maybe the vendor's IT systems have been compromised by some kind of hacker or threat actor, and this threat actor is using the vendor's compromised systems to then gain access into your systems, right? So that is the kind of monitoring that would first be helpful to alert you to the potential breach that's occurring, but second, also to demonstrate to the PDPC that you were very alive to that particular risk of a security breach happening on the vendor that might contaminate or that might jump to your systems, right, through the vendor's access that's being granted for that vendor relationship. Next would be audits and on-site inspections. So this is another kind of common monitoring and reporting tool where you conduct audit exercises, you get an independent audit report, or you do an on-site inspection at their premises to make sure that to check and make sure that they are handling your data properly, that the systems are all properly secure, that they're storing your data correctly and safely, whatever, all those different kinds of things. And finally, if your organization is conducting a simulation or tabletop exercise to mimic or simulate a data breach, it's also worthwhile considering involving your vendor, especially for those key vendors who are going to handle a large amount of your personal data. Like, for example, if you're an e-commerce company, a lot of your data is going to be handled and processed by your logistics partner, who's going to make your deliveries for you, right? All your orders, all your customer details, all their transactions, all their transactions or whatever are going to be processed by them in order to deliver your customers' orders. Because of that level of data processing, it's worthwhile to consider including this key vendor, in any kind of tabletop or simulation exercise that you do, so that in the event of any kind of breach, either on your end or their end, I guess if you're including them, it will be on their end. If there's some kind of data breach that happened with your logistics vendor, that both you and your vendor are prepared and able to effectively and properly react to that data breach incident and effectively manage it in accordance with the plans that you are the data breach response plans that you develop together and have tested in the course of this tabletop exercise. Right. So the last portion of the data intermediary life cycle to manage would then be in terms of exit management. When it comes to establishing clear timeframes for the DI to cease retention of the personal data after it completed your processing activities. Right. So now that the relationship is winding down, you're no longer going to work with this vendor. It's important to make sure that the data that is with them is properly managed and handled in the course of this exit process, right? And what this would involve would be various things, but including things like the DI to ensure that all work done is fully documented, and that documentation is handed back to the data controller upon completion of the project. I think this is particularly relevant in the case of major IT projects like data migration, right? Because of the amounts of data that they're going to be handling and moving around in the course of that project, it's important for them to have documented what they've done and what they've not done, so that the data controller can refer to the documentation to see where exactly the data has gone from point A to point B to point C, or system A to system B to system C, that kind of thing. And also importantly, test scripts and test results, right? Because as highlighted in the case study earlier, testing is quite an important aspect of vendor management. And I guess I probably should have highlighted this in the earlier section as well. But testing is quite important because it's part of the ability or the obligation of the organization to make sure that when deploying a system to handle personal data, that system is properly tested to make sure that it can and will in fact handle the data as envisaged by the parties, and not in some kind of different way in an unauthorized manner. And the test scripts and test results are important documentation of those testing, right? So that even after the relationship is ended, the company, the data controller can look back at those test scripts and test results to see, did something has gone wrong on my platform, for example, that this vendor built for me. Was this issue tested? What was the test results? And and why is it going wrong now, right? Is this something that we failed to take into account, or was it something that was already accounted for, but something else happened after the testing to make it go wrong? Next, what other parts of exit management would include exit audits and checks to make sure that the data intermediaries has abided by and is going to abide by the agreed plans, both in terms of the previous service relationship as well as in the course of the exit. And also when it comes to the data, whether it's going to be handed back to the data controller or passed on to a new vendor who's going to take over the service, whatever kind of data is properly transferred and returned or disposed of or whatever, so that it is not floating around somewhere, or it's not kept by the data intermediary even though they no longer are in the vendor relationship with you. Right, so having gone through the data intermediary management lifecycle and kind of at a principle, at an operational level, what you need to think about. I'd like to go back to the specific issue of developing contractual clauses. For a number of reasons. I think first, this is probably the most natural thing you think about when it comes to managing a data intermediary. And also because it's the most tangible form of data intermediary management, right? A lot of these are processes that need to exist and need to be communicated and implemented. But at the end of the day, when things go wrong, when somebody hasn't done something, when there's a data breach, it's the parties will always turn back to the contract to see who messed up, right? Who was supposed to do something but didn't do it. And the contract is the document which will legally determine the allocation of the responsibility and the risk between the parties. That's why it's relevant. But over and above that, the contract is also important because in the event of any kind of investigation by the PDPC in a data breach where it involves the data controller and the data intermediary, the PDPC will always ask for the contract between the vendor and the company to see what kind of obligations in terms of data protection have been imposed by the company on its data intermediary. So that's the baseline requirement that the PDPC will always ask for. Over and above that, if you can give to the PDPC other documents that evidence your robust vendor management processes, like all the things that I was talking about earlier, like your audit checks, your monitoring tools, your reporting frameworks, that kind of thing. Those all definitely go even further towards strengthening your demonstration of compliance to the PDPC. when it comes to managing your data intermediary. But the first and baseline thing is always the contract, right? So when it comes to developing the contractual clauses and negotiating them with your data intermediary, there are some things you probably want to think about, lah, right? And these kind of tie into the different aspects of the data intermediary lifecycle. First, from a governance and risk assessment perspective, what you want to put into place is typically, first, a prohibition against any use or disclosure of the personal data by the DI for any unauthorized purposes. So you have determined what are the specific data processing purposes you're outsourcing to them, and you are gonna impose a prohibition on the data intermediary to use that personal data or disclose that personal data for any purpose outside of those predetermined purposes that have been set by you. Next, you want to set out what are the specific data protection measures that the data intermediary is required to put in place in order to protect the personal data entrusted. On this note, I think it's quite common for contracts to just have a very generic, you will comply with the PDPA in handling any personal data that I give to you. That is like fine at a very, very basic level, but at the same time, it creates two potential challenges. I think the first is that if you're not specific enough as to the obligations that you're trying to impose on the data intermediary, there can be some kind of doubt or argument as to whether a certain act that you had expected them to do, whether that act was covered within your generic clause or not, right? Because you didn't specify it, then it leaves it open to argument as to whether they are expected to do this thing or not. Second, when it comes to the PDPC's assessment of your data protection compliance when it comes to data intermediary management, it definitely doesn't look as strong or definitely doesn't look as favorable when you have a very simple and generic clause compared to where you have very detailed and robust clauses, right? Because it demonstrates to the PDPC that you had clearly applied your mind to the risks involved in engaging this data intermediary, and you had accordingly drafted out very clear and specific obligations into the contract that would address all these risks that you identified. So on a similar vein, the policies and practices section of the data intermediary lifecycle that I mentioned, those would also need to be translated into the contract like I mentioned. And what this would comprise of would be things like prohibiting subcontracting or requirement of the DC's approval before subcontracting. Because I think this is important because a subcontract, if basically what you're trying to do is to manage your vendor, right? And impose contractual relationships or contractual obligations on that vendor. If the vendor can then subcontract the data processing, the issue is then that your company, you do not have a direct contractual relationship or even any kind of operational relationship with that subcontractor, right? Because you are only talking to the main contractor, the data intermediary here. So the potential risk involved here is that whatever you impose on the data on the data intermediary kind of doesn't apply anymore once they've engaged a subcontractor and they passed on the data to the subcontractor. And if anything goes wrong at the subcontractor level, you can't rely on whatever clauses you've put in place vis-a-vis the data intermediary. Two additional points I will add to this though. I think first is that typically what you want to do in the contract is that first you will prohibit the data intermediary from subcontracting without your consent, so that if they are going to subcontract, you are aware of what subcontracting is going to take place, how much subcontracting is going to happen, and based on the risk that you can assess from that subcontracting, you can either consent or don't consent, right? Secondly, there is a particular case that the PDPC has decided, which does indicate that if let's say there was okay, in this kind of factual scenario, right, whereby you had engaged a data processor, and the data processor had then subcontracted that service to another party without your knowledge or without your consent. You as the primary organization would not be expected to control or impose contractual obligations or controls on that downstream sub-processor, right? Because it's not somebody you have a direct relationship, it's not somebody you even knew about. So in that case, there has been a decision by the PDPC which indicates that the primary organization would not be liable even if there's some kind of data breach on the end of on the part of the downstream data sub-processor. So which is why it's all the more important to make sure that such subcontracting is properly controlled and restricted within your contract with your data intermediary, so that if they then breach that requirement and then pass on the data to some other party without your knowledge or consent, you are not only protected by the against any kind of regulatory liability because of that case, but you are also protected contractually, right? Because you are able to allege a contractual breach by the data intermediary because of their unauthorized subcontracting. And the second point here is similar to what I just said, in that whatever kind of even in a situation where you have permitted that subcontracting, you should require the data intermediary to first impose the same obligations on the in terms of data processing on its subcontractor, and second, to continue to be legally responsible and liable to you for any acts or omissions of their subcontractor. So in other words, they need to have a contract that reflects your own contract and mirrors whatever obligations you have imposed on the data intermediary. But at the same time, if the data intermediary does something wrong, so if their downstream subcontractor does something wrong, you are able to claim directly against the data intermediary for that particular breach. So you have twofold protection in that sense. Next, your contract with the data intermediary should clearly specify that in the event that there is a data incident or data breach involving your personal data, the personal data that you are handed over to them, they must notify you without undue delay. This is critical because of the fact that under the PDPA, if there is a data breach involving your personal data, and in other words, personal data that you have passed on to your data intermediary, you as the primary data controller will bear the obligation of assessing whether the incident needs to be notified to the PDPC, and if notification is required by law, to file the notification with the PDPC within the stipulated timelines. It's not an argument for you to say that I had given the data to my data intermediary, so in any kind of data breach, nothing to do with me. Absolutely not. As I mentioned at the start, the responsibility for complying with the PDPA will still sit with the primary data controller, and therefore it is important for the data controller to be notified by its data intermediary of any kind of data incident that the data intermediary becomes aware of, so that the data controller can discharge its own obligations under the PDPA. The next point here is to deal with the transfer limitation obligation under the PDPA. So specifically, to enable the data controller to comply with this obligation, the requirements of the PDPA need to be reflected in the contract by making sure that if there's any kind of overseas transfer of personal data to be done by the data intermediary, like for example, the data intermediary has a few servers located in different locations around the world outside Singapore, this transfer must be done in compliance with the PDPA. And this can be done in a number of different ways, but typically you would just require them to ensure that the data recipient overseas is bound by legally enforceable obligations to ensure a comparable standard of protection with the PDPA. And the final point on this slide addresses the compliance with the consent obligation. So in a situation where the data intermediary is supposed to help the data controller obtain consent on behalf of the data controller before they collect, use, or disclose any personal data, there must be very clear obligation to do so to obtain such valid consent on behalf of the data controller. So overall, these are just some examples of the kind of clauses you want to put in. And at a more general level, to kind of summarize what clauses are expected. Okay, sorry, maybe I'll summarize that after this slide. So when it comes to the third portion of the data intermediary lifecycle, service management, so this will be the ongoing management of your vendor. You will want to contractually document what are the reporting measures, reporting obligations, or monitoring obligations you want to implement. Because again, like I mentioned, it's twofold, right? You want to put it into the contract, and then you also want to operationalize it in your day-to-day operations. Your audit rights need to be put into the contract. Your on-site inspection rights need to be put into the contract, so that at a day-to-day level, you can then effectively implement them, because you already documented it in the contract and because the vendor has already agreed to it. And finally, when it comes to exit management, the requirement for them to return, destroy, anonymize, delete, or whatever, the personal data that you had given them when the vendor relationship is over, that also should be documented in the contract. Okay, so to sort of summarize the different contractual obligations that you might want to think about, there's two levels to this. I think the first is looking at the PDPA's obligations, right? The 10 or 11 different obligations that you as the primary data controller will need to comply with. And thinking about which of these obligations need require the vendor's cooperation, or requires the vendor to do something or not do something in order to assist you to comply with those obligations, or to prevent you from breaching those obligations. So as you can see, some of these points that I've highlighted here are specifically targeted at enabling the primary data control organization to comply with its own obligations under the PDPA. For example, you see this timely return or destruction of data. This is to enable the primary organization to comply with the retention limitation obligation. The earlier parts about no undue delay in reporting data incident or breaches, this is specifically targeted at enabling the data controller to comply with the data breach notification obligation of the PDPA, right? So you want to look at what are the obligations under the PDPA that you need to comply with as a data controller, and think about how you can translate those obligations into contractual clauses to enable you to comply with those obligations through the assistance of your data intermediary, or by preventing them from doing something, right? Either requiring them from doing something or preventing them from doing something. The next level you want to think about, aside from those obligations, and I think it's kind of related as well, would then be specific operational measures that you want to put in place in order to both comply with the PDPA, but also just to manage the vendor relationship in general. So to the extent that there's very specific things that you have, it's very specific policies and processes that you have developed, those should be translated clearly and specifically into the contract as well. Like, for example, if you expect the vendor to submit to you quarterly reports on something, or if you expect the vendor to allow you to audit, or if you expect the vendor to segregate your data from other customers, or things like that, you want to spell all of those out very clearly in the contract, in order to have that obligation imposed on the vendor, and if the vendor subsequently doesn't do so, or decides that it doesn't want to do so, you can point to the contract and enforce it against the vendor. Right, so that is kind of the bulk of what I wanted to share today. And I guess I'll wrap up by sharing a bit more about the resources that the PDPC has helpfully published and put on its website to enable organizations to kind of deal with what I was talking about today in managing data intermediaries. There is a guide to managing data intermediaries that's published by the PDPC. You can find it on the PDPC's website. And that's kind of that kind of forms the source of what I was talking about today, right? Everything I talked about today in the slides, it originates mostly from this guide. Next, there's also a primer on managing data intermediaries published by the PDPC. that's kind of more of like a one-page summary that the PDPC has done, summarizing the guide lah. So if you just want a quick and dirty look of at what it means to manage data intermediaries, you can look at this primer as well. There are other resources that the PDPC has put in place on its website. These are general in nature. So I mean, these are not limited to managing data intermediaries. But I will reiterate to all of you, because I mean, this is something that I mentioned at the previous seminars as well, that the PDPC does have a fair number of resources that they have published on its website that are quite helpful for organizations, especially those who have cost constraints when it comes to complying with the PDPA. There are a bunch of free resources that the PDPC has made available on its website, and the PDPC has also put in place a number of frameworks that are targeted at addressing those cost concerns, such as the data protection essentials program, that can enable SMEs, for example, to engage the PDPC's approved list of vendors to get a sort of templatized package of basic data protection documentation and things like that. Other programs that the PDPC has would include things like the Data Protection Essentials program that I just mentioned, and certifications that the PDPC has put in place, such as the Data Protection Trust Mark, the APEC cross-border privacy rules certifications, and also the Better Data-Driven Business program. To find out more about all these different programs and how your organization can benefit from them, please feel free to visit the PDPC's website via this QR code or just going directly to the website. So yeah, that brings me to the end of my presentation today. Happy to take any questions that you guys have.
Thanks, Justin. So I think currently there are 3 questions in the Q&A, but if any of y'all have any more questions regarding what Justin just shared, please feel free to drop them in the Q&A. So Justin, the first question is, when or under what condition would it be necessary to follow any of the 4 steps of the DI management lifecycle? Does it apply universally or depends on the company, startup, or ground up?
So the framework applies universally. When it comes to the framework, right, as I mentioned, it represents the 4 different stages of your life cycle with the vendor. Your company, regardless of which stage your company is in, if you're going to engage a vendor to do data processing on your behalf, there's always going to be a initial pre-selection stage. There's always going to be an onboarding stage. There's going to be a steady state stage whereby you're managing the day-to-day relationship, and there's always going to be an exit stage. So I would say that all 4 aspects of the data protection lifecycle are relevant to all organizations. But what I would add, I guess, is that for smaller companies like you mentioned, startups, it definitely can be a bit more challenging to fully implement everything that I said, right? Because whether due to cost considerations, manpower issues, resource constraints, you're not going to be able to do all of them. So instead of thinking about which of the 4 can I skip, I guess it's more important to think about, in each of the 4, what are the key areas or key factors I want to focus on, because these represent key risks for my company, and these are important things that I want to focus on and zoom in out of the different 4 elements. At a baseline level, I would say that the contractual clauses are in fact the most basic and important requirement. No matter what, you need to have those contractual clauses imposed on your vendor, because at the end of the day, that is what you're going to fall back on if anything goes wrong, right? If the vendor does or doesn't do something, you will always rely on the contract. Over and above that, you need to have certain policies and processes in place internally so that you yourself know how you are handling your personal data, and you yourself know how you want your vendor to handle your personal data. So when it comes to how robust or comprehensive it is, I do recognize that not every company can implement the full suite of what I mentioned today in full detail, right? So pick and choose your battles, figure out what are the important things you want to zoom in on, and focus on those accordingly.
Thanks. The second question, normally when DC engages a service provider, is the SP provides the service contract, how can the DC get the SP commit to the protection and retention obligation? Should the DC have a generic contract to sign with all SP?
So I guess this kind of boils down to your things like your bargaining power as a company, and also how you engage and also the vendor's general customer engagement procedure lah. What I would say that is not necessary to quibble over your template or my template. At the end of the day, what is necessary is for the clauses to be in place lah. Right. So obviously you start with your own template, then that is definitely easier because as a starting point, you already know that those clauses are there in your own template, and you all you need to do is just to make sure that the vendor agrees to it, right? As a starting. So if negotiation wise, it's always easier to start from your own template. But again, definitely that's not always going to be possible. There are definitely going to be vendors who insist on using their template, and because they have more bargaining power than you have to agree. What you should do in that case is to then review and negotiate their contractual terms and put in place the necessary contractual obligations required for you to comply with the PDPA. And the fact that you need those clauses to comply with the PDPA is a strong reason for you to request the vendor to put it in lah. But taking it further, I guess there could also be other situations whereby it's not even possible to engage with the vendor, because they're just too vague, or they don't even contract with you at a direct level, right? You're just signing onto a set of online standard terms. In those situations, then it's more of a question of risk assessment. You should review that vendor's terms, their standard terms. You should review their security commitments. What is their security policy? What is their security track record? And decide for yourself, are you going to trust your data with this vendor, even if you cannot specifically impose the contractual obligations? It could be possible that they already have some commitments in their own template contract that are sufficient for you to rely on to comply with the PDPA. In which case you don't need to renegotiate or specifically insert your own language. So again, it's a case by case question, and ultimately it boils down to relative bargaining power of the parties lah. But ultimately, your end objective is always the same, to make sure that the relevant obligations are there in place so that you can address the data processing risks.
The next question is it an acceptable practice in the market to, one, review the vendor's policy and procedures, or two, require them to share their external audit report, three, audit the vendors ourselves if we need to?
I would say generally yes. That is considered fairly standard if you look at things from if your perspective is that of robust data security and data protection compliance, right? Definitely for larger companies which have strong bargaining power, those are definitely things that they would typically want to insist on, and they are able to insist on vis-a-vis the vendors. But again, as I alluded to my answer to the earlier question, it's not always possible, right? It's always a question of relative power between two parties. So even though you tell your vendor it's typical, they may not agree. So in which case, again, you need to do a proper risk assessment, figure out which of these things are more important. Like if you can rely on their own independent audit report, then you don't need to kind of go in and do your own audit, right? So kind of figure out what is the line that the parties can agree on. What is the level of comfort that you can reach based on what they can commit to.
The next question is, do you have to ask your clients permission before outsourcing data?
I suppose when you say your clients, you mean the individuals, right? The individuals whose personal data you've collected and are using. Generally, the answer is yes. Under the PDPA, the consent obligation is quite clear. If you're going to collect, use, or disclose your personal data for any particular purpose, you need to have the consent of the individual involved. But what I would say is that the consent only needs to be tied to the purpose and not to the specific vendor who you are going to engage for that purpose. So if for example, let's take the example of employee payroll processing. Right. In your internal privacy policy with your employees or your employment contract or whatever, if you have already obtained their consent that you would or you may be disclosing their personal data for the purpose of payroll processing, that is enough consent to enable you to disclose the personal data to your payroll processing vendor already. The contract doesn't need to specify and they don't need to consent specifically to, I'm going to engage vendor XYZ for this purpose. It's enough that they've consented to the purpose. They don't need to consent to the specific vendor, but consent for the purpose is necessary before you engage the vendor for that purpose.
Okay, what's a good way to set up these contracts at scale, especially for a small startup that move fast?
So if you the most efficient and scalable way to do it is to have a template data processing agreement, right? Whereby if you have any kind of data processing, if you're going to share your personal data with any third party for any reason, you have a template in place that you can just give to that person, be a vendor or whatever third party who's going to receive the personal data. And that data processing agreement will already set up all the different data processing obligations that you want to impose on anybody who receives your personal data. So that is the fastest and most scalable way to do it, right? Because you have one template, you can just replicate it across any different kind of contract, right? It'll just be an ancillary contract to that main contract. It would have to be tailored to some degree depending on the circumstances, but you wouldn't need to redraft the whole contract from scratch every time, right? You can just use off that same base template.
Okay, I think that was the last question. We'll give a minute or two to see if there's any more questions. But meanwhile, if you have attended all three sessions of this whole series, we'll reach out to you after this webinar in the next few days to check in with you on your certificate, your certificate of participation as well. So yeah, I think there's no more questions. I think so that's it. Thank you, Justin. Thanks everyone for joining us. We'll send over the slides after this webinar as well. So thank you. Have a great afternoon.
All right. Thanks, everybody. Cheers.